What's going on with Erica O'Neill?
Mr. Etheridge is down in Buchanan's, and David said he told him
Did he speak to her?
no.
He doesn't know that. They sent an email regarding the review, but there was no update, so I didn't know if you wanted to flush it out. There's an email about what? Because she's supposed to see a competency matter, and then she's supposed to be special. On the record in the matter of the people of the state of Michigan versus Erica O'Neill, 24-02381. Ms. O'Neill, please start your video.
Morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Attorney Derek Eschendos, public defender on behalf of Ms. O'Neill, who is appearing by video.
Okay. Ms. O'Neill, today was the date that was scheduled for a preliminary examination. I'm sorry, probable cause conference. Let's see here. I think this was a matter that was supposed to be referred to a specialty court. How are we proceeding?
That's correct, Your Honor. We're still waiting on the assessment to be completed in the mental health court. I did email Ms. Fesson over the last couple of days. She's still in the process of completing the assessment. One issue is that there were some pending cases in Genesee County that we're trying to get some information about before she finishes the assessment. So we're just asking the court to reset it again.
People have no objection.
Attorney,
Your Honor, I'd say 30 days. If we can get it done and get the transfer order done before then I can just turn the paperwork in and not need the court date. But I think that would be more prudent to have it set up a little bit
February 20th at 9. February 20th at 9. O'Neill, do you have any questions for the court? You're muted.
No, I don't.
Any additional matters for the record, counsel?
No, Your Honor. Thank you.
No, Your Honor, thank you.
Okay, all set.
Thank you.
The record in the matter, where's Ashley Allen? She's in jail. Matter of the record of the state of Michigan versus Ashley Allen, 24-01847.
Morning, Your Honor. Matt Nagel for the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, who's appearing separately by video.
Today was the date and the time that was scheduled for a probable cause conference. How are we proceeding on this matter?
Your Honor, we do have a plea if I can approach with the pretrial.
The offer is for Ms. Allen to plead guilty to malicious destruction of property less than $200. Is that accurate?
That's accurate, Your Honor.
Yes. And the people are going to dismiss the remaining charge and drop their habitual offender.
Sorry, I should read that we were going to amend count 1 to, or I'm sorry, We're getting used to this pushing. All right, I apologize. Dismissing count one, Your Honor, is that what I'm saying? What I'm putting?
Okay, you're amending count one to malicious destruction of property less than 200. And you'll plead guilty to that. And you're dismissing that habitual offender.
Yes, well, once I dismiss count one, yeah.
Well, it's amended.
Yes, Your Honor.
Thank you. Ms. Allen, you heard the offer extended by the people
Yes, ma'am.
to accept that offer.
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Okay, you have the following rights that you need to understand and that you would need to give up if you want to accept the offer. First is the right to the presumption of innocence. You're innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to require the prosecution prove your guilt by proceeding to jury trial and requiring to prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses that they intend to call to testify against you, and you can waive your silence and testify at your own trial if you'd like. Do you understand that?
Yes, ma'am.
You also have the right to have witnesses subpoenaed on your behalf. These are all rights that you would have to give up if you want to plead guilty today. Is that your understanding?
Yes, ma'am.
Anyone threatening you to give these rights up and plead guilty to the amended charge?
No, ma'am.
Promises being extended to you in exchange for a guilty plea today.
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea could result in a conviction that you may need to report to your current or future employer.
Yes, ma'am.
It also could have impact on where you can get immigration status or where you can travel outside this country. Do you understand that?
Yes, ma'am.
As to the amended count one of malicious destruction of property less than 200, how do you plead?
Guilty, ma'am.
Actual basis.
Thank you, Your Honor. All right, Ms. Allen, on February 26th of 2024, you were released on house arrest from Ingham County Jail with a tether, correct?
Yes, ma'am.
And then you returned at sometime that day. You were returned back to Lansing, correct?
Yes, ma'am.
And then at some point during that day and in the city of Lansing, did you knowingly and without authority remove your electronic monitoring device?
Yes, ma'am.
Your Honor, no further questions.
Any questions from the prosecution?
No, Your Honor, thank you.
Court is satisfied with the factual basis. I'll accept your plea and I find your plea made freely, voluntarily, and intelligently. Do we know what happened with the electronic monitoring?
It was recovered in several pieces.
Oh, so then there should be restitution.
I believe though that we didn't talk about it, but I believe that they would already be for money, but I don't know.
I'll follow up with JSG, Your Honor, but by the time we come back.
Sentencing set for March 13th at 9 a.m. You need to meet with our probation department so they can prepare a pre-sentence report and provide an update to the court as to how they believe you should be sentenced.
She will be in custody until April 1st on the current sentence she's serving.
I'll note that so that they make contact with her while she's in custody at the Ingham County Jail. Do you have any questions today, Ms. Allen?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
No.
Okay, you're all set for today, ma'am. Christina Jann here. Christina Jann's not here.
No, check.
No one's in the hallway.
So was I okay to go with it, ma'am?
You're free to go.
Thank you.
Christina Jann. No, ma'am.
I don't know where Mr. Palmer is. Have you seen Mr. Palmer?
I think Ms. Nickel is filling in for Mr. Palmer this morning. She was just in here. Let's see.
Record in the matter of the people of the state of Michigan versus Christina Marie Jann, 24-02241. Appearance, please.
Good morning, I'm Robert Hayes, Assistant Attorney General here for the people, P69006.
Good morning, Your Honor, Tara Nichols from the Nottingham County Public Defender's Office on behalf of and stepping in for Mr. Palmer this morning.
You see Ms. Jann?
And that's me.
Okay. I don't know if Mr. Palmer has had contact with her at all since.
We have had contact with her, Your Honor, and it was Mr. Palmer's intention he was available to create the 21 days.
Fails to appear the probe issue of bench warrant and bond forfeiture. Any additional matters for today's record?
Now, for the people, Your Honor.
You're all set.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you. The record in the matter of the people of the state of Michigan versus Dennis Molitor, 24-00014.
Good morning, Your Honor, Matt Nagel for the people.
Good morning, Your Honor, Stephen A. Freeman, Assistant Public Defender, appearing on behalf of Molitor, who appears by Zoom.
Mr. Molitor, can you hear us?
Yes, Your Honor.
Okay, today is the date and the time that's scheduled for a probable cause conference for home invasion, first degree assault and battery and domestic violence. There's a preliminary examination scheduled for January 24th at 9 a.m. I think it's probably been moved though to 2 p.m.
Yeah, it was moved to 2 o'clock, Your Honor.
Are we continuing to exam?
Sorry, Judge.
Are we continuing to exam?
Yes, Your Honor.
Need to address anything on the record today?
Only that if I could please convey to Mr. Molitor that I need him to contact me, come in and see me. There's an offer on the table that I very much need to discuss with him. And we're having difficulty communicating.
Mr. Molitor, what's the problem with contacting your attorney?
Your Honor, I just called him yesterday and left a voicemail.
What's your phone number?
It's 517-894-4937.
Okay, that's the number we have in the file. Your attorney's going to call you, okay?
Okay, Your Honor.
Okay, we'll see you in person next week at 2 p.m. for your examination. Any additional matters for the record?
No, Your Honor, thank you.
No,
Your
you're
Honor, I have a
okay.
question. Sorry,
Yes.
sorry, I didn't mean to interrupt the court, but is it possible if I can get this tether removed?
Just because you want your tether removed, is that what you think is gonna happen here?
No, I'm just asking, is it possible if I can have that removed today?
Why?
I've been following all rules and regulations. I haven't violated anything. I've paid my fines with them. I'm just wondering if I could possibly have it removed today.
And I'm glad to see that in the last 10 days, you've been following the rules. I'm not amending your bond nor taking off the GPS tether.
Okay, Your Honor.
Thank you.
Yes, sir.
You're all set.
Okay, thank you.
You're welcome. Okay, well, we're all caught up to 9:30s. Why do I have this guy? Is this for today?
Yeah, they wanted to adjourn. I asked them to submit a Stit.
So today?
Yeah, next page.
The exam.
Oh, did you change? That's what she said. Kristen. In the garage.
At 8:30, he texted me that he would see me in an hour. At 8:31, he said he'd see me in an hour. It's like now exactly 60 minutes from me. So,
It's usually timely, so he could be downstairs.
you said February 14th.
February 14th, Your Honor.
I wouldn't object to that.
I'm sure we would be ready.
February 28th
February 28th
and 9:30.
at 9:30.
On the 28th. We'll be here.
No,
And
sounds
we'll be
good.
ready.
Sounds good. Any additional matters?
No, thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome.
Getting out of the car, so maybe in the garage.
In the garage, 'cause Tricky's in
That's
there.
correct. That's correct.
Here's his return.
Hurry up.
Okay, I don't know, let's see. Union County has not put Dennis on yet. Schroeder has Forrest and Larkin.
I'm so sorry. Sorry, Toby.
Any of your clients here?
She is not here, but she has made contact with me, Miss Larkin. She literally she said she was going to be here in person momentarily. She just called me and she. about
We
5
have two
minutes.
cases.
Yes, that is the one I have had contact with. The other.
Forrest, you did not have contact. Oh, she had been one.
I made attempts, like it's not. Thank you.
No. Mr. Goodrich, you're here on Stit, Nathan.
Yes, I have not seen him yet, but I talked to him on the phone multiple times yesterday.
Yeah, she did, she called and said she was in the next 5 minutes.
Discuss it. All right. And besides, I read the page court. I see what you're saying, you know, I'm seeing. Oh, I don't know what happened to it. But I do see why. Yeah. Yeah. Somebody just skipped a step and they got messed up, but I can see why they.
What I don't understand, they only do that.
That, I just figured, I think it's not clear. In the video. And then there were two people that put my contract. One was the dad, one was the person who was on the contract. I think it's unclear. Why wouldn't you read it? You just said. Yeah. Yeah, I was confused with this. Yeah, I was confused. Yeah, that was the first time I've seen it. I'm confused too.
Okay, so Mr. Stit Nathan is here.
So they just requested a bench warrant, or we just requested that. So. So it was your card because it's. What have your. Number 6276.
Yeah, that's why I was trying to get up there. All right.
I have this one. I'm not following how this is mine. It's my case or Buchanan? Is this case mine or Buchanan's? It's an LT case.
You guys can call the number.
Case number?
So downstairs.
Zero. 290.
Perfect, thank you so much.
Yeah, of course. I'll be.
Trying to understand why she doesn't know tonight.
Yeah. Oh, yeah. Yeah, I'm fine with that.
Send us the receipts.
She told me.
She was going to the judge record. Oh, that's the one
Well,
where
the sooner I have it.
that she did enter the disqualification on it.
I'm gonna chase it down. So if you have receipts, just unless you file.
That one just had a pre-trial.
We'll request it.
Right, that's why I'm trying to put the note in. When we set it for hearing? Yeah. On the 12th.
So
The car set.
then you'll have something from the insurance company.
Oh.
So, yeah. Yes. So just answer what you have. I'll answer your questions. I got other cases.
Yeah.
Okay. Thank you. Thanks for being.
Yeah.
I'll thank you. You get my phone.
Yeah.
Okay.
Okay.
Thank you.
Thank you.
So David emailed me those two documents. I know the message.
You don't want to just stick with it then?
Right, I'm not.
We ready to go on record? Yes. We're ready on record and recording.
Oh my God. I don't know.
That's okay.
I don't know if I received it yet.
No, it probably
Oh,
hasn't come across yet. I
okay.
just wanted to give you a heads up.
Okay, sounds good.
Thank you.
No problem.
Exactly. That's what I'm getting at. Wait, okay, cool. Oh,
One of them should.
I don't remember which one it was. It was an MSP guy.
Yeah.
He's got a mustache.
Yeah.
That doesn't count it down.
Are you heading back in there?
I am, yeah.
Alright, that one's running. Can you just give me a heads up? I'll be there as soon as.
Okay, yeah, so that, the Sydney one was running.
Yes.
Okay.
Yeah, thank you, Evan.
On the iPhone.
Hello.
What's your name?
Christina Jann.
I'm supposed to be here at 9 o'clock.
I had trouble zooming in. My connection it wasn't.
Okay, I issue a bench warrant, so you need to turn yourself in on the bench warrant.
Huh?
I issued a bench warrant for failure to appear. You need to turn yourself in on the bench warrant.
Ma'am, my Zoom wasn't connecting.
Are you laying down?
No, I'm not. I'm sitting up.
Oh, yeah. You need to turn yourself in on the warrant today.
I live all the way in Dearborn Heights. I'm not able to come all the way to Lansing.
Okay, well then you should be here on time for court. when the attorneys are here waiting for you?
Ma'am, my Zoom was not connecting. I was having trouble zooming in.
Who did you contact to let them know that?
I didn't call my attorney. I called the courts.
You didn't call the court.
I did.
You did not. Anything else we can help you with today? There's nothing I can do. Your attorney's not here, neither is the AG, and they were present at the date and time that you were supposed to be here. No one had heard from you, nor did you contact the court. So a bench warrant was issued. You're all set for today. You need to take care of your bench warrant and call your attorney.
Okay. Thank you.
On the record in the matter, the people of the state of Michigan versus Brent Dennis 25-00004 and 25-00038. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Dennis. He is appearing with us remotely from the Ingham County Jail.
Okay, we have one file, assault with intent to murder and assault with a dangerous weapon. The other file, police officer assault, resist obstructing and controlled substance possession. Both matters are scheduled for a preliminary examination next week on the 24th. Are we continuing to stand?
Your Honor, at this time, I would be petitioning the court to have Mr. Dennis evaluated for competency. I have those filings prepared for the court on each file.
You're unable to, or you believe there's a concern about his competency?
I do, Your Honor. Mr. Dennis has extensive mental health history. And I have met with him and spoken with him a couple times along with our social worker. And certainly the information provided in the discovery, I think would indicate the same. So I have various serious concerns that he would not be able to fully appreciate or understand the nature of the proceedings against him or be able to adequately assist counsel in any court hearings. Certainly the stakes are very high. Mr. Dennis is facing life in prison. So I would ask to have him evaluated for competency.
Yeah, paperwork.
I do, if I may approach.
Thank you. And the prosecution is not objecting.
No objection, Your Honor.
Thank you. So. For the defendant to undergo an examination as to competency will be entered for today. Because of that, we'll find good cause to go beyond the 21 days on each file, and the matter will be set out for review. Additional matters that we need to address on the record today?
No, Your Honor. Thank you.
Just, Your Honor, is that are we going to have a date certain for that review hearing at this time, or will that be set at a later
I
time?
think the clerk's office will set it.
Okay.
Okay.
All right. Thank
You're
you,
all
Judge.
set. You're all set, Mr. Dennis.
Yeah.
Thank you. We did not see Ms. Forrest, that's correct. You can let the deputy know you're ready to go.
Yeah.
Thank you. Okay, on the record in the matter, the people of the state of Michigan versus Ayanna Larkin, 3-03218.
Morning, Your Honor, Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Larkin. Ms. Larkin is present and I'm standing to my right.
Okay, Ms. Larkin has a probable cause conference today for police officer Plea and scheduled for exam on the 24th at 2:30. How are we proceeding on this?
Thank you, Your Honor. At this time, we'd be asking the defense would be asking the matter be left set as it is. I spoke with Ms. Larkin today. We have confirmed her phone number and we will be ready to proceed on that day. Thank you.
Okay, sounds good. So we'll see you at 2:30 in person. Do you have any questions?
Oh, yeah.
Any additional matters for the record?
No, Your Honor, thank you.
Thank you.
You're welcome. Thank you. On the record in the matter of the people of the state of Michigan versus the priest Stit Nathan, 24-02841. Also here.
Morning, Your Honor, Matt Nagel for the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Stit Nathan, who is standing to my right.
Okay, this matter was scheduled for preliminary examination today. Are we running an exam?
My understanding that we are running an exam this morning,
Yes, Your Honor.
Any preliminary matters before we call witnesses?
not for people.
You want to address the? Okay, all right. No, Your Honor, nothing from the defense, Your Honor.
Call your witnesses.
The people call Trooper Pump.
You can have a seat.
Trooper Pump. Please stand up, face the judge.
I'll be sworn in. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Thank you. You can have a seat. There's a microphone in front of you. That microphone does not amplify your voice, and it will only pick up for the court recorder to be able to make a record. I need to be able to hear your responses, so if you can just raise your voice a little bit more for me, so you can go beyond that glass, okay? State your first and last name and spell both.
David Poff, Davidpoff.
Thank you. You can proceed, counsel.
Thank you, Your Honor. Good morning, Trooper Pump. Thank you for being here, sir. Can you tell the court with whom you are currently employed?
Michigan State Police,
How long have you been employed by the Michigan State Police?
just under 3 years.
And what are your current duties with the Michigan State Police?
Law enforcement, road patrol.
Road patrol? Okay. And what are some of the things you do as your responsibility on road patrol?
Respond to dispatch calls and make traffic stops.
And were you working in this capacity on September 21st of 2024?
Yes.
Is that a yes?
Yes.
Sorry, I just need the microphones to pick it up. Do you recall making a traffic stop early in the morning on September 21st?
I did.
Can you explain to the court the nature of that traffic stop, please, sir?
I saw a vehicle entering, coming from Waverly Road, getting onto eastbound 496. Using my vehicle radar system, vehicle in front of me produced a reading of 87 miles per hour in a 70 mile per hour zone. Traffic and the vehicle crossed the dotted white line multiple times, and a traffic stop was initiated on 496 eastbound MLK.
So in the basis of the traffic stop was for speeding, I think you said?
Speeding and improper lane.
Thank you, sir. Did you approach that vehicle after the vehicle stopped?
I did.
Do you recall how many people were in the vehicle at the time of the traffic stop?
There was four.
4 people. Do you see anybody in the court today that looks like one of the 4 people that were in that vehicle on that day?
I did.
Can you point to him and identify an article of clothing, please?
White shirt.
And the record reflect that the trooper indicated the person sitting at defense counsel table, and will the record reflect ID, Your Honor?
No objection.
No objection.
Identification's noted.
Thank you, Your Honor. Can you explain to the court what happened once you made contact with, actually, let me ask you this. The person you indicated in the court, was he the driver of the vehicle?
No.
Where was the person sitting at, that you indicated earlier, where was he sitting in the vehicle at the time?
He was behind the driver.
So backseat, driver's side?
Yes, sir.
Thank you, Trooper. What happened when you made contact with the driver? Can you explain that to the court?
As I was approaching the car, the rear driver's side passenger opened the door. Due to how long it took the vehicle to stop, I told them to, ask them to produce their hands. I made contact with the driver, notified him of the stop.
Did you ask for the occupant's IDs?
I did.
Is that a usual part of your traffic stop?
Yes.
And did the occupants provide their identifications?
The driver did, and the rear passenger side occupant provided me their IDs.
So the defendant that you indicated earlier and the other person in the vehicle, what was the problem with their identifications?
The priest said that he was underage and that he did not have an identification.
Okay, you said LaPriest. Is LaPriest the person that you indicated in court earlier?
Yes.
Okay, so LaPriest, the person in the vehicle who was sitting behind the driver's seat, told you he did not have ID. So with that information, what did you do? Do you remember?
I guess I don't. Can you rephrase the question?
Yes, sir. So since he was unable to provide his ID, did you do anything to confirm?
Oh, I asked him what his name and date of birth was, for which he provided a false name.
How did you know it was a false name?
He messed up his date of birth and he stuttered and had trouble providing the name and date of birth, which is a common question that should be answered easily.
Okay, so it sounded like he wasn't being truthful.
Right.
How were you able to confirm that he had gave you a false date of birth?
He messed it up one time and gave me 2 different date of births.
Okay, that's what I was getting at. So he gave you 2 different dates of birth?
Yeah.
I see. So what did you do next?
I believe at that point I went back, or I asked the driver to step out of the vehicle, and that's when I got a verbal consent search on the driver and detained him until my backup arrived.
Okay. That's the driver of the vehicle?
Yes, sir.
What about the person in the back seat, driver's side? The person you indicated was Mr. LaPriest. What did you do with him?
Once my backup arrived, I had him step out. Verbal consent search was completed, which then I asked him if he wanted to try again. He gave me his name, which he then provided me his real name and date of birth.
And were you able to confirm that?
Yep.
How were you able to confirm that?
Ayanna Lin.
Okay. Before Mr. LaPriest stepped out of the vehicle, Did you see him do anything else inside the vehicle that caught your attention?
After asking to see his hands, he was making furtive movements, and I saw him reach under the seat, the driver's seat of the vehicle.
So, so not under his own seat, but reached down
In front of him.
in front of him. Could you see what he was reaching for?
No, at that point I could not.
Did you find anything on him when you conducted your consent search?
No.
Did you inquire of anybody in the vehicle about what maybe somebody thought they saw him doing?
I asked one of the occupants of the vehicle, I asked what interviews were conducted with all of them, who they all said that they had just met him today.
Okay. And did you said you had backup on scene at this point. So I'm guessing you didn't do a search of everybody, just the driver and Mr. LaPrice? Does that make sense? Yeah, I beg your pardon. I asked it very strangely. Did you do a search of anybody else in the vehicle?
Yeah, I did. I searched everyone in the vehicle.
Oh, you did? Okay, thank you. Did you find anything on anybody else?
No.
Did you ultimately search the vehicle itself?
Yes.
And why did you search the vehicle?
On a consent search from the driver.
From the person driving the vehicle?
Yes.
Did you check the registration of the vehicle during this traffic stop?
I did.
And were you able to determine who the vehicle belonged to?
I was.
And who does that vehicle belong to? Do you remember?
It was a female, and it was not female in the passenger seat.
Okay. Were you able to determine whether that the owner of the vehicle was related in any way to anybody in the vehicle?
I was not able to confirm that, no.
I'm sorry, 1 second. Do you recall whether or not anybody had told you that the vehicle belonged to somebody's wife?
Yes.
And who told you that?
The priest told me that it belonged to his wife.
So LaPrice, the person sitting in the back seat behind the driver, not driving, claimed that the vehicle belonged to his wife.
Correct.
You said that the driver gave you consent to search the vehicle?
Correct.
And did you conduct that search, sir?
Yes.
And did you find anything of evidentiary value?
Yes.
What did you find, sir?
I found a loaded handgun under the driver's seat.
Underneath the driver's seat. Do you recall whether under the driver's seat it was close to the floorboard of the driver's seat, or was it underneath the driver's seat close to the back seat? Do you recall?
It was close to the back seat.
Close to the back seat. So, and what kind of a weapon was it, sir?
It was a pistol.
And were you able to check the registration, whether or not that pistol was registered?
I was.
And were you able to ascertain an owner of that pistol?
The pistol came back in lien as stolen.
And did you talk to anybody about that pistol? Yes. Who did you speak to about it?
Yeah. I guess I'm not understanding.
Did you ask Mr. LaPrice about the pistol?
No, he waived. He did not want to speak to me after being read.
Fair enough. Did you ask any of the?
He didn't want to speak to you after what?
After I read Miranda.
So he did not want to waive his right to remain silent.
Correct.
Fair enough. Did you speak to anybody else in the vehicle about the pistol?
Yes.
And did anybody tell you that the pistol belonged to them.
Objection, that's hearsay, Your Honor.
Objection sustained.
That's fine. I have no further questions here. Actually, yep, I have no further questions.
Morning, Trooper. Okay, so when you pulled the vehicle over, you stated that you were still on 496 near the MLK exit, is that fair?
When I initiated. the
Yes.
stop, yes.
In that vehicle, you said continue to drive, but when you say continue to drive, did they essentially take the next exit on, like, for South Walnut there?
Without looking at a map, I'm not entirely sure if that is the next exit from that road.
Okay, but you do state in your report that the vehicle came to a stop on South Walnut, correct?
The vehicle came to a stop on Walnut or?
Yeah, well, let me ask it, so do you recall which street that the vehicle did eventually stop on?
I believe it was Washington.
Washington, okay. So essentially this vehicle continued on, basically took the next exit, or well, you don't remember exactly, but they took, was it Emmett, then Malcolm X for a little short drive there and then turned right onto Washington, is that what happened?
Yes.
Okay. And in your experience, is a vehicle coming to a stop on South Washington there kind of a safer stop for you to conduct than one that occurs on 496 itself?
I guess as far as amount of traffic. or-
Yes. I mean, safety to the officer who's got to walk up to a vehicle.
Yes.
And you stated that it was not Mr. Stit Nathan who was driving that vehicle, correct?
Correct.
When you stopped the vehicle, you stated it was because of both speeding and crossing the white line, correct?
The dotted white line.
And those would both be civil infractions, correct?
Correct.
And when you approached the vehicle, you immediately ordered everyone to put their hands on. What did you order them to do with their hands?
I believe I asked them to, I'm not sure exactly what I asked them to do with their hands, but I said something to the sort of, let me see your hands.
Okay, and is that standard procedure for somebody for a speeding stop in your experience?
When the vehicle takes that long to stop, and the windows being tinted, the totality of the circumstances there.
Which
I
windows
felt
were tinted of the vehicle?
I'm not sure exactly all the windows that were tinted.
All right.
I have this quick question in here. You said it took them so long. How long did it take them to stop?
I'm not sure exactly how many minutes it took them. But it was not a. It was not immediately after I turned my lights on. I had my lights on for quite some time and took multiple different roadways to get to where we eventually were.
You were on, this happened on the expressway? Was it on 496? Because I thought you said that it began at Waverly in 496.
That's where I observed the vehicle.
You observed them at Waverly and 496. Were you on 496 at the time, or were you on Waverly?
When I first observed the vehicle, we were both on Waverly and took 496.
Okay, so you both got on to get on 496 off of Waverly. And so how much time from the time that you got on at the Waverly entrance to the expressway until you activated your lights? Like when did you activate your lights to stop them?
After observing the improper lane use and observing the vehicle to be going 87 17 miles an hour over the speed limit.
Okay, so you were traveling behind them at the same time and using the radar?
Yes, I was using my moving radar.
Okay.
to my vehicle.
Okay, do you know where you were when this happened? Because I'm trying to see how far you were from where they pulled over.
I initiated the traffic stop on. I activated my lights on 496 and MLK.
496, okay.
Okay, and then, like I said, so then you followed the vehicle off the exit ramp at that time? And when you say Malcolm X, that's right in front of the General Motors plant, correct?
I'm not sure, it was the business that is right there.
But there are no, I guess, roads that actually go south until you get to Washington when you get off the freeway at that point. Is that correct?
I'm not sure what roads go south from.
Okay, that's fair. If you don't know, you don't know. And you immediately ordered the driver out of the vehicle, correct?
Not immediately, no.
Okay, when did you order the driver out of the vehicle?
After he handed me an identification card. Identification card.
Why would you have ordered him out of the vehicle after he gave you his ID?
An identification card does not. He told me that he had. Or he gave me his identification, which was an identification card and not a driver's license.
Okay. Okay, so you're saying he gave you an ID card, not a driver's license.
Right.
And did you take that identification and go run it through Lean? Or whatever your system is to identify him, to see if he did have a driver's license?
I did eventually, yes.
And he did in fact have a driver's license, correct?
Correct.
Then I guess at what point is he ordered out of the vehicle?
When he produced an identification card and not a driver's license.
All right. And then the other three people are still in the vehicle at that time?
Yes.
And at what point do you start ordering other people out of the vehicle?
Once my backup has arrived.
And I guess under what grounds are you ordering people out of the vehicle? Why are you ordering people out of the vehicle?
Because of the amount of time that it took for the vehicle to stop and then the furtive movements under the seat.
Okay, but when you're talking about a time frame, I mean, you're talking about 15, 20 seconds, correct? You were not talking about several minutes.
I couldn't tell you the exact time frame.
And you said you stated you see these movements, but you never see a gun or anything illegal, correct?
No. At that time, no.
You had still, and so, but based on what you stated, that you ordered all people out of the vehicle. Correct?
Yes.
And Mr. Stit Nathan consented to having his person searched outside of the vehicle?
Yeah.
And did you find anything on his person that was illegal in any way?
No.
And did you find anything that would be evidence of possession of a gun, such as a holster, cartridges, anything like that?
No.
And then at some point you checked who the vehicle was registered to, correct?
Yes.
And was that a woman by the name of LaShante Funk?
Yes.
And was Ms. Funk on scene?
No.
And did you learn from Mr. Stit Nathan that he had some type of relationship with this woman?
He did tell me that she was.
And
who told you this? Is it Nathan, did you say?
Yes.
And at some point was Ms. Funk was on a phone call with Mr. Stit Nathan on scene?
I believe that who he said was on the phone.
Did you speak with this woman while she was on the phone? See if to make any effort to confirm if it was her or not?
Did I talk to her on the
Yes.
phone? No.
Instead, you get permission from, who was it that consented to search the vehicle again?
The driver.
Okay, the driver of the vehicle, but you knew he was not the owner of the vehicle, correct?
The registered owner?
Correct. And you made no effort to speak with this woman on the phone who they were claiming was the owner? That's correct?
Correct.
And basically you use a consent from a person that you knew not to be the owner of the vehicle because that was going to get you into the vehicle. Isn't that correct?
Can you say that again? I'm sorry.
Yes. Yeah. Well, let me rephrase that. If you had spoken to the owner of the vehicle and she denied permission to search the vehicle, that would have prevented you from being able to search that car, correct?
Based on a verbal consent search, yes.
So you had no interest in speaking with her based on that, correct?
I guess I did not speak with her, no.
Okay.
So I don't think that was a question. The question wasn't, did you not speak with him? I think we understand that. His question was, did you not speak with her because you didn't want to seek her consent?
That is not why I didn't speak with her.
And then was it you who conducted the search of the vehicle or was it a different trooper?
Initially, it was me.
And you stated that you found some type of firearm in the vehicle?
That is correct.
Did you also get some type of DNA swabs from Mr. Stit Nathan to see if that would match anything found on the gun?
Did I get DNA from his person?
Yes.
No.
Okay. Was that something you would have referred another officer to do? Or, I withdraw that question. I think I may have stuck it out from there. Did you make any efforts to see if there was any type of fingerprints or DNA on the gun that would match it to one specific individual or not?
I did get DNA swabs from the firearm.
Are you aware if those found any DNA or anything?
I have not gotten lab results from. No.
All right, no further questions at this time, Your Honor.
Just a couple of follow-ups, Your Honor. Trooper, there were some questions about where you first identified the vehicle and then where you initiated your lights. Do you remember that being asked that on cross? Yes. I think you indicated an area of 496 and MLK. I think that's where you indicated you first saw the vehicle. Is that right?
That is where I initiated my traffic stop.
That's where you initiated your traffic stop. Okay.
I first observed it on Waverly Road getting on to 496.
Okay. At Waverly Road and then where the traffic stop ultimately occurred. Those locations, those are in the city of Lansing, is that right? Yeah. And that's the county of Ingham? Yes. Excellent. I have no further questions.
Follow-up. When you stated that you noticed some furtive movements, when did you notice these furtive movements? Was it when you had approached the vehicle or prior to approaching?
So it was after I had asked the occupants to keep their hands where I could see them or something of that matter. And it was after I had asked them to keep their hands where I could see them.
Okay, so you initiate a traffic stop, you approach the vehicle and immediately ask everyone to keep their hands where you can see them? Is that what you're saying?
And upon approach, the rear driver's side passenger opened the door. And that is when I said, let's keep their hands where I could see them.
And then after you gave that command is when you started to have, you noticed some furtive movements or
Correct.
gestures?
Correct.
Like what kind of gestures?
The rear driver was leaning over, reaching down towards his feet or towards the underside of the driver's seat.
Okay, so his hands would not have been where you could see them after you had said for everyone to keep their hands where you could see them?
Correct.
And then you said that you initiated your traffic light or traffic signal, emergency signal, I should say, at MLK, and they stopped, they came to a stop at which exit? Was it Washington?
It was Washington Ave.
Isn't that the next exit?
They got off 496 and eventually stopped on.
They didn't stop right at the exit, they kept going.
They kept, yeah, they took the exit and then turned, I believe, it would be south.
On Washington.
On Washington.
Okay. Where on South Washington did they stop?
It was. I would have to look at, it was north of a street. Not sure exactly what the street.
I thought I was thinking about Walnut, and that's what I was thinking. Walnut's not in that direction, so I was a little thrown off.
If the court, if it would help the court, I can show you how the trigger his police report. It would help, if it might help refresh his memory.
Refresh his memory, yes, please.
Trooper, did that help refresh your memory?
Yes. So the vehicle took exit 6, and then eventually stopped just north of Hazel on Washington Ave.
Okay, sounds good. I don't have any other questions. Any cross or redirect based on my question?
No, thank you, Your Honor.
No, Your Honor.
May the trooper be excused?
You may, yes, Your Honor.
Thank you. You may be excused. Any other witnesses?
No other witnesses, Your Honor, however. Under statute 76611B, I have spoken with counsel prior to the start of this hearing. I do have a record of judgment. The defendant in this case was previously convicted of breaking and entering a building, 2 counts, as well as larceny in a building. There was sentencing under HIDA, but I also have a record of the result of a probation violation while he was sentenced under the Youthful Trainee Act, where the order indicates that that trainee status was revoked. The record is not certified. However, I spoke to counsel about this prior to the start of the exam. And it sounds as if there'd be no objection to offering this under the same method statute.
That is correct. The defense did not object to that at this time. I do recognize the signature of Judge Dragonshaw on both of those documents.
Thank you, Your Honor. And with that, the people restroom.
Is the defense counsel are any witnesses today?
We are not going to call them next.
Proceed to argument.
Thank you, Your Honor. The people would ask that this matter be bound over as charged. In count one, carrying a concealed weapon. As the testimony indicated, the reason for the traffic stop was for speeding and improper lane use. The vehicle did not immediately stop, but though that by itself is not indicative of greater things. In addition to that, I think the testimony was that as the trooper got out, the rear door opened, which caused the trooper to ask that the occupants keep their hands where he could see them. And then while questioning people inside the vehicle, the rear seat driver's side person identified as the defendant had given the officer false information. Taken in aggregate, all of these things together, the officer did have some concerns about what may be going on. Then the officer had requested consent from all of the occupants to search their persons as well as the vehicle. Based on the consent search and observations from the trooper, the testimony being that the trooper had seen that same backseat driver's side passenger making some movements toward his feet when he searched that part of the vehicle. Underneath the driver's seat, close to the back seat, a 9mm pistol was recovered. That person, again identified as the defendant, also indicated to the trooper that the vehicle belonged to his wife. Under those circumstances, based on the jury instructions, first that the people showing that a pistol was in the vehicle, that has been established in testimony. The trooper found a pistol underneath the driver's seat inside the vehicle. Second, that the defendant knew the pistol was there. The testimony offered gives us some circumstantial or reasonable inference that the person in the back seat probably knew the pistol was there, since the person was reaching down toward his feet while sitting in that part of the car with the pistol located near where the defendant would have been sitting. And third, that the defendant took part in carrying or keeping the pistol in the vehicle. Again, under the same inference, reasonable inference under the circumstances, the defendant reaching down and potentially manipulating the pistol to try to keep it hidden, it would indicate that the defendant took part in carrying or keeping the pistol in the vehicle. Also supported by a reasonable inference where the defendant offered that the vehicle belonged to his wife. Not dispositive by itself, but also, again, circumstantially leading to, with everything else in aggregate, leading to a reasonable inference that the defendant would have known and taken part in keeping the pistol in the vehicle. Second, in count two, firearms possession by a prohibited person, we've submitted a judgment of sentence, a judgment of conviction regarding the defendant. He has been convicted of a prior felony, making him ineligible to possess a firearm. And then with count three, that would be the accompanying felony firearm to go along with count two. Based on the testimony, as it's been presented to the court, we would ask again that this be bound over on counts 1, 2, and 3, along with the habitual offender notice. Thank you.
Thank you, Your Honor. Your Honor, first of all, I believe none of these counts should be bound over for two significant reasons here. One being the finding of the gun appears to be discovered as part of an illegal search of the vehicle. The trooper was aware that the driver was not the owner of the vehicle. The owner of the vehicle was on the phone to talk with him. He chose not to, so he could use consent from a person who didn't have the authority to give the consent to search the vehicle. So I believe that the evidence discovered thereof should not be admissible in this. There were 4 people inside the vehicle at the time. The officer testified that the windows were all tinted, which was part of his concern, but yet he also claims, on the other hand, that he's seeing these so-called furtive movements. He testified that he never saw Mr. Stit Nathan touch a gun. He never saw a gun inside the vehicle until he had ordered everybody out of the vehicle and began his illegal search. There was nothing on Mr. Stit Nathan's person that would corroborate him being in possession of a firearm in any way. He was not the owner of the vehicle. We do not know who these other three individuals were. So based on the fact that there's nothing directly tying him to the gun in the vehicle, and the fact that I don't believe that the gun should be treated as evidence based on the search, we would ask the court to deny bind over on all three counts. Your Honor. Thank you.
Today was the date that was scheduled for a preliminary examination. You have count 1, weapons carrying concealed, count 2, weapons, firearms, possession by prohibited person, and count 3 of weapons, felony firearm. There's an habitual offender fourth offense notice. The burden is on the prosecution to establish sufficient probable cause that these felonies were committed. So they don't need to prove each element beyond a reasonable doubt. They just need to show more than mere suspicion that the crimes alleged occurred and that you were the person that allegedly committed those crimes. And the court was the sole determinant of credibility of any witness and outweigh the likelihood of the prosecution's success at trial. And so count 1, being weapons carrying concealed, requires the prosecution to establish, at least to a probable cause standard first, that the defendant, or that a pistol was in the vehicle that the defendant was in. We had testimony today from Trooper David Paul. He testified that on the date September 24, 2024, that he had effectuated a traffic stop at the area of 496 at or near Washington, at or near Hazel. That's in the city of Lansing, Ingham County, state of Michigan, which would make venue in this court appropriate. At the time of the stop, or prior to the stop, the officer said he had first noticed this vehicle traveling in the area of Waverly on 496, and that he observed the vehicle to be driving in excess of the speed limit. I think he said it was about 87 miles per hour, I believe. And that the vehicle crossed the dotted white line multiple times. So a traffic stop was effectuated for speeding and improper lane use, which we know to be civil infractions. Officers indicated that there were some tinted windows. He wasn't clear, or could not recall, I should say, as to how many of the windows in the vehicle was tinted. I meant to ask what time of day that this was, and I never asked. Nonetheless, the officer testified that as he was approaching the vehicle, I think there was a rear door that was open, that he advised for all of the occupants of that vehicle to keep their hands where he can see them, that he asked for ID from the driver, and driver's license, to say, and the driver provided ID instead of a driver's license. He said that he observed some furtive movements in the back of the vehicle, primarily by the person who identified in the court today as the defendant, Mr. Priest Marquel Stit Nathan, and that he appeared to be reaching down in front of him in some form or fashion. This is after the officer giving instruction to keep your hands where I can see. The officer or trooper testified that he requested ID and primarily from Mr. Stit Nathan, that Mr. Stit Nathan provided information that he was underage, that he didn't have identification, and then gave, I believe, 2 incorrect dates of birth, and he seemed to halt or stutter while giving his name and date of birth, causing the officer to question the validity of the information. The officer received, or I think had ordered the individual out of the vehicle, did a pat-down search, didn't locate any contraband. Officer got consent from the driver of the vehicle to search the vehicle. there is testimony to the effect that the potential owner of the vehicle was on the phone with the defendant, and that potential owner may or may not have been the defendant's wife. And the defense is objecting to the validity of the search based on the fact that the officer did not seek consent from the person who was on the phone. Before we address the objection, let me continue to go through the jury instructions as to the elements of the crime. Again, we have testimony that there was a pistol that was located. It was located under the driver's seat. When questioned, the proximity of the location of that pistol, that it was located, he said, close to the back seat, which would indicate to him that it was placed by the back seat driver's side passenger. The second element is that the defendant knew that the pistol was there. I think there's circumstantial evidence based on the location in which the officer found the pistol, in addition to the furtive movements that would support at minimum circumstantial evidence to a probable cause standard that the defendant knew that there was a pistol there. Third, the defendant took part in carrying or keeping the pistol in the vehicle. We think the evidence circumstantially that would support that would be if this in fact was the defendant's wife's vehicle. He had some relationship with the ownership of the vehicle, that there was a firearm located right in front of where the defendant was seated in the vehicle, and that the defendant was seen by this trooper making furtive movements just before this firearm was located, and this was after the officer had indicated, keep your hands where I can see them. So I think taking the collection that supports probable cause that the defendant took part in carrying or keeping the pistol in the vehicle. Now, as to the objection to the validity of the search and whether or not the officer could lawfully search that vehicle without the consent of the owner, there was testimony or I think cross-examined question that was posed to the trooper about the defendant being on the phone and with someone that purported to be his wife and someone who was purported to be the registered owner of the vehicle. That may or may not have been accurate. The officer can't see through the phone and find out who's on that phone. But what we do know, and this is supported by the law, is that owners can give consent to search a vehicle, but also that when you are driving someone's vehicle, then you're in possession of them, that you now have a reasonable expectation of privacy in that vehicle, but that you also have the ability to give consent to search the vehicle when you are the driver of the vehicle. I don't know why, if it was I don't know who the driver was, and I don't know why, if it was the defendant's wife's car, why someone else would be driving while he's in the back. I have zero idea. And then it sounds like the person who was driving didn't have a license anyway, so none of it really makes sense there either, but that's for the finder of fact to flesh out at the time of the trial, because the matter will be bound over on count 1. Count 2, weapons, firearm, possession by prohibited person. Again, having sufficient probable cause that the defendant did in fact have a firearm in the vehicle, and then now information in support of a prior conviction by way of a judgment of sentence that was signed by Judge Joyce Dragonshock on August 17, 2020. Which would make the defendant ineligible to carry a firearm unless he had regained the eligibility requirements. That supports and suffices for probable cause as to count 2, weapons, firearms, possession by a prohibited person. And there's a count 3 of felony firearm to accompany count 2. Both those counts will accompany count 1 to the circuit court, and the habitual offender 4th offense notice. The bind over date is going to be January 29th. And that's the date the circuit court gets the file from the district court. It's not a date that you, Mr. Stit, Nathan, need to appear in the circuit court, okay? Your next court date's going to be a pre-trial in the circuit court. Your attorney will be made aware of that date so that you know when you need to appear. Is your address still the address on Massachusetts Avenue?
No.
No, you have an address on South Penn?
Yes.
Okay. Phone number ending in 3966. Your phone number ends in 3966.
Yeah.
Okay, any changes to your contact information, you need to make sure the court is abreast of that so that you don't miss any of your court dates. Nonetheless, bond will continue at 5,010%. Any additional matters for the record?
But not from the fence, Your Honor. Thank you.
Thank you. You're all set. And Mr. Nagle, you can get your paperwork.
Thank you, Your Honor.
Right, so I'll have to contact them.